Well, as of yesterday, Australia now has radical new anti-bullying laws in place. A worker who's been bullied at work now has a right to take their claim to the Fair Work Commission, which has been given quite far-reaching powers. Well, here to tell us what these laws mean for Australian workplaces is our regular guest commentator, Joydeep Hor, Managing Principal of Specialist Workplace Relations law firm People and Culture Strategies. Joydeep, good to see you. Tell us, obviously we've been speaking to you a lot about these anti-bullying laws coming into place. Tell us exactly what is the definition of bullying now?
Yeah, it's a really important issue to understand because bullying has become a very overused term in the last few years, and certainly as a lawyer working in this area, we've seen an absolute groundswell of complaints of workplace bullying, particularly in the last 2 or 3 years. It is a very subjective notion for a lot of people, but as far as these new laws are concerned, there's a very clear definition. And that definition is that a worker has been bullied at work if another person or group of persons at that workplace has subjected them on a repeated basis to conduct that isn't reasonable and also that has created a risk to that person's health or safety. Now, there is still a bit of subjectivity in that in terms of determining what is reasonable versus what is unreasonable conduct, and that in itself is not further defined in these new laws. So one of the questions and challenges for businesses in particular around these new laws is, well, where does performance management sit? What's our ability, what's a manager's ability or a supervisor's ability or a boss's ability to say to someone, look, you're not performing well, if you don't lift your game, there could be some consequences for you, I might have to fire you, I might have to give you a warning or a whole range of other things. What if that person responds to that particular feedback and says, well, I didn't think that was reasonable, that has made me unwell, that's caused me to be stressed and anxious about whether I'm going to keep my job. So they're the kinds of things that are going to play out, and we think play out fairly quickly. There's been a big build-up to these laws which came in yesterday. So the next few weeks are going to be very interesting, next few months even more so.
Yeah, absolutely. So, I mean, who can bring a claim and how is this process going to work?
Yeah. So a claim can be brought by any worker, and worker is defined very broadly. It will obviously be an employee. It will also be independent contractors. It'll be work experience students. So there doesn't actually have to be a formal employment relationship. It's basically that broad definition of anyone who is doing anything that resembles work, even in a workplace context. In terms of the process, the person will lodge a claim with the Fair Work Commission, and the Fair Work Commission has an obligation to deal with that within 14 days. Now, we've got some clarity in the last few weeks from the Fair Work Commission that their understanding of what that requires them to do doesn't mean that they have to actually have any kind of hearing in that 14-day period. It might just be an administrative exercise, but something will happen in the first 14 days. What we expect is going to happen very shortly thereafter is that there'll be a conciliation conference where there'll be some attempts made by the Fair Work Commission to try to resolve the matter before it needs to go to a formal hearing per se. What we also know is that the names of the parties are not going to be published in that first stage, and that's very sensible and very important because there are going to be a number of claims that will be made under these new laws that have questionable merit, and people's reputations and potentially careers and livelihoods could be irrevocably damaged if there's not some steps taken to protect those reputations. So that's protective towards those individuals. If, however, it doesn't resolve in those early stages, it's then going to have to go to a formal hearing. And that's going to be a massive distraction for businesses, potentially with orders being made, if the Fair Work Commission finds that there was bullying, that are quite far-reaching and quite unprecedented, because the Fair Work Commission will have the power to make any order that it sees fit to stop the bullying. The only thing the Fair Work Commission can't do is make a monetary order against any individual or against an organisation, but it can do everything else. So it can stop two people from continuing to work together. It can order that someone who has been found to be a bully undergo some kind of training, coaching, behaviour modification or any number of other things. So look, this is quite unprecedented, not just in Australia, but also at a global level. These kinds of laws so broadly constituted as far as the definition of bullying and the far-reaching powers are unheard of anywhere in the world.
So what can organisations do to prevent a claim?
I think the first thing they need to do is build an awareness around what these laws are about, because there's still a lot of organisations who don't think that it has any relevance to them. they do need to understand that bullying is now very squarely on the radar. They must have, and this is an absolute not negotiable, they must have policies within their organisations that make it very clear that the organisation will not stand for bullying. They must be very clear in terms of their education of all of their staff. And similarly, they must have quite well-documented procedures for how someone should deal with an issue if they feel that they have been bullied at work. Because one of the things the Fair Work Commission can do is give a bit of leeway to an employer that has policies and procedures in place, and particularly where an employer has conducted an investigation internally in relation to a particular complaint. So they're the things that are fairly essential. Organisations, though, that are going to be protected from adverse repercussion under these laws are going to be those organisations that are well sophisticated in terms of addressing cultural issues, understanding those personalities within their organisation that could be problem employees for them, working on those individuals in terms of coaching and stylistic improvements and whatever. We're going to see a whole range of behaviours that are going to be scrutinised, and no one really knows exactly how this is going to play out. Myself included, it's all about analysis based on paper so far. The reality will be borne out in the next few weeks.
Yeah, and I guess too the number of claims that will be brought as well. I think the estimate is for 3,500 claims in the first year, but I mean, what's your thinking? Do you think there'll be a lot more than that?
Yeah, I think that number is significantly understated, and I think the number of complaints will actually be a lot more than that. And the reason I say that is that in my experience and our experience as a firm, we see that floodgates open fairly quickly when it comes to workplace relations matters. There's a lot of emotion and angst that people bring to their work. Understandably, people put a lot of time and energy, and it takes up a big part of people's lives. So the consequences of what happens to someone at work are usually things that a person feels that they want to do something about. The moment someone knows that there are claims that they can bring, whether it's for harassment or bullying or whatever else, there's a curiosity that's sparked that often links to what's been happening to them at work. And so once they see some of these cases get the publicity that I'm sure they'll get in the next few weeks, those floodgates will well and truly open.
Joydeep, it's great to hear all about this, what business needs to be doing. Thank you so much.
Pleasure.
Joydeep Hor there from People and Culture Strategies.